Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today's topic for discussion would be on the recent landmark ruling delivered by the Honorable Supreme Court of India in the case of Union of India versus Ashish Agarwal, wherein certain 90,000 income tax reassessment notices that were issued after the 2021 amendment was saved by the Honorable Supreme Court. And as a quick recap, approximately 90,000 reassessment notices that were issued by the income tax department under the old tax regime. There was after 1st of April 2021, but these notices had become subject matter of controversy because certain amendments that had already taken place, and as a result of which they were challenged in various high courts, High Court of Allahabad, High Court of Delhi, Bombay High Court, Honorable Rajasthan High Court, etc. And most of these high courts had quashed these reassessment notices, except for one, which was Honorable Chhattisgarh High Court, and which ruling was in favor of the revenue. Thereafter, matters had reached all the way up to the Supreme Court, and eventually the Honorable Supreme Court had decided in favor of the revenue, saying that the department should be granted some leeway, since the officers may have been under some bona fide belief that the amendments have not yet been implemented. Now, was there a bona fide mistake? Or was there some definite misadventure on the part of revenue? Was it a deliberate could this Honorable Supreme Court of India exercise under Article 142 of the Constitution of India in a tax matter to come to the rescue of the revenue? What are the possible implications of this order? And should the SSEs be compensated for that? Now, joining us today on the virtual amicus, well, is a very distinguished tax attorney. She needs absolutely no formal introduction. She argues corporate tax, international tax, transfer pricing issues in the tribunal, High Court, Supreme Court on a daily basis. Her clientele includes large MNCs, Fortune 500 companies, etc. She has a very deep and thorough understanding of intricate tax issues. So joining us on the virtual amicus is a taxation specialist. We are joined by Ms. Ananya Kapoor, who is presently working in the chambers of Mr. Salil Kapoor in Delhi. And just to give you all a brief introduction about her amicus for today's session, she did her BCL, Masters in Law, from the prestigious Oxford University. She secured a distinction there, and she was also awarded with the Salve Scholarship. She's an adjunct professor at the Jindal Global Law School, and she's pursued her law from Indraprasth, where she was also awarded the University Gold Medal, and she had won back-to-back for 5 years. She's been a winner of the Best Student Award successively for 5 years individually, and she's also recognized as an India Tax controversy leader back in 2020, and also as best rising star in taxation in 2020. And she's here to explain what that verdict means, what that possible implications could be, and what issues have been resolved and what issues were there before the Honorable Supreme Court. So thank you so much, Ananya, for taking out time for doing this session. It's really very important section in the field of taxation. Anything that you wish to say before we start with your session?
No, that's a lovely introduction. Thank you. Thank you so much, Jay. It is great. Jay and I have known each other professionally on and off for a really long time. I think this initiative that Jay has of this platform, it's an amazing platform. And he's been calling people from all different forums within the legal framework, legal industry to come and talk. So right from retired judges to upcoming lawyers to people who are, who are on this side or on the other side, both bar and bench is getting covered, so different perspectives get covered whenever a topic is being done by Jay. It is amazing. It's a very good initiative. So thanks, and thanks for having me here. Now to talk about today's big topic, reassessment and 90,000 notices. So 90,000 assessees and taxpayers are subject matter of the litigation and the controversy which is going on for the last almost 1 year. And whether the Supreme Court has settled it or not, or whether it has unsettled a lot of issues, is something we'll be talking about in the next half an hour to 40 minutes. My favorite line for the Supreme Court judgment is Operation Successful, Patient Dead. And why? I think in another half an hour, we'll probably know how so many things, maybe a Pandora's box has opened in terms of how, what, why. Because, okay, see, one thing is whether the Supreme Court rules in favor of the assessee or in favor of the taxpayer, that's a separate matter. But while doing so, what do we expect? We expect some guidelines, we expect some rationale, we expect answers of a lot of open ended questions. It's not the ultimate solution or the ultimate answer that I'm talking about. Supreme Court judges decided one way or the other, which is fair enough. But in that entire process, the process and the decision making, has that given us a lot of solutions for these 90,000 taxpayers who have received notices? And that is the subject matter that we are trying to understand today. I've made a small PPT. I will not try and bore everyone, but I will just run through a lot of provisions because this may be a new concept for all of you. So just to give some brief background of what exactly is reassessment, what happened by Finance Act 2021 and how did this entire controversy in the litigation framework start. So I'll just put my PPT on the screen. You can put the next page. So what exactly do we mean by reassessment? What is reassessment framework under the Indian taxation regime? The Indian taxation regime follows a system of self-assessment. And by self-assessment, I mean that each taxpayer, each individual, each company, each litigant is subjected to income tax procedure as per the return of income that they file. So you, as per your own understanding of the income tax framework, apply the entire provisions of the income tax law and you file your own return, which is the concept of self-assessment. So I self-assess my taxable income and I file a return. Once I file my return, it can either be accepted as it is, or it will be subject to a scrutiny assessment. That means you'll receive a notice, and then there'll be discussions back and forth. Earlier, it used to be physical in form of us sitting with the assessing officer and explaining it to him, and now we are in the faceless regime. But having said that, there are two concepts. That means once I file my income tax return, either I get my return gets accepted and there is no scrutiny assessment, or my return is subjected to a scrutiny assessment. And after a certain time, because time is of essence in terms of giving certainty and clarity to your returns, and they need to close for each assessment year and each financial year. Let's say you get 21 months, 24 months to complete the assessment, and then the matter closes. So 24 months from the end of the financial year, from the end of the time when I file my return, some certainty is achieved qua each assessment year, each return for each year closes. Once that closes, then the issue that arises is, can we reassess? So the power of reassessment is given to the revenue. That means within the time frame that was given to the revenue did not finish the assessment, or they finished the assessment and subsequently certain new information comes to their hand, qua which they have reasons to believe that your income has escaped assessment and hence a reassessment is required. So you're out of the framework of the original assessment, that time period is over, but it's a beneficial provision for the income tax department that after a certain period they can still go ahead and reassess, and they can reassess you based on certain information that is available in their hands, which they feel requires a further investigation and a further inquiry into your income tax return which you have filed. So the power of reassessment right from the beginning, since the time it's been there, even under the old law prior to Finance Act 2021, even under the old law, there's been a lot of jurisprudence in terms of understanding what is reassessment. And a lot of safeguards have been put within this. So, for example, I put it on the screen. There has to be excessive reasons to believe. There has to be tangible material. You have to link that material with some escapement of my income to show that, yes, there is a reason why this power which has been given to the income tax department needs to be exercised in this present case, because certain information is there to show that certain items which had to be subjected to further investigation have gone missing in the first place. So it's a power which has been given to the income tax department. And in fact, there's a Supreme Court judgment of Sun Engineering under the erstwhile regime, which says that this is a power in favor of the department. So it is not a power in favor of the assessee. An assessee cannot take the benefit of 147 and make a new claim. This is a power which is only given to the income tax department to protect the interest of the revenue, and hence to make sure that if subsequently certain information comes within the hands of the revenue qua particular taxpayer, then they can use that information and reassess, even though the time frame for the original assessment already stands concluded and completed. So this is what primarily speaking reassessment means. And then over a period of time, the entire framework of the reassessment law went a lot of changes. There were a plethora of judgments on this aspect, because even under the erstwhile regime, we used to file a lot of writs challenging the very legality of the reassessment on different aspects. It could be change of opinion, it could be no tangible material, it could be reasons to believe, reasons to suspect. Taxpayers would typically argue that no, the original assessment framework already took care of all of this, so there is no reason for you to do a reassessment. Whereas the department will argue that no, subsequently there is information or there has been some development which allows us to extend the time period and use the extended time period of reassessment to look into the return and do further investigation. So that would always be the typical arguments. And there was a lot of jurisprudence which kept developing over a period of time. The matter even reached Supreme Court on several accounts. There's Kelvinator, there are a lot of Supreme Court judgments. Then came about the judgment which is called GK and Raisha. Next. So GK and Raisha is one famous judgment. in which Supreme Court kind of laid down the procedure. So the Supreme Court, it's a very small judgment, but they said that no, once a reassessment notice is issued, you can ask for the reasons recorded. Reasons recorded form the very framework. That means what are the reasons available with the assessing officer under which he has reasons to believe that certain income of yours has escaped assessment. Because, like I mentioned, the original scrutiny assessment framework time period is already over. And this is a special power given to the revenue to give them a second chance, in simple words. So, to give them a second chance to have a real look at your income tax return, which has already attained finality qua the original time period which is permitted in law. So, how can they exercise this power which is given to them? They need to record reasons that XYZ are the reasons which we feel require further investigation and a further inquiry into the income tax return qua the taxable income. So they issue you the reasons recorded along with the 148 notice, you file your return, all of that. And then you even give them objections that I object and I say that you cannot touch my income tax return for XYZ reasons. After which they are bound to pass an order. So the last line, if you see on the screen, says, and then the assessing officer is bound to dispose of the same by passing a speaking order. So this entire framework is not part of the erstwhile regime of 147 and 148. It is all a judge-made law. So another fetter was put in terms of passing another order before passing the reassessment order as a matter of checks and balances. And this is why the Supreme Court judgment of GK and Raifsha became very famous. The court said, since this is a special power and you are touching somebody's return for the second time and you did not do it under the original time frame given to you, we are creating this system and this framework under GK and Raifsha, as a result of which you will first issue him your reasons recorded. The person will object to it and you will pass a separate order disposing of the same. So it's another leg, another system of checks and balances. Then all of this happens before my reassessment happens. So before my original reassessment notice is passed under section 147, before that, this precondition was imposed under in terms of GK and Raifsha, in terms of laying down certain law as a system of checks and balances. Then over a period of time, this developed even further. The next judgment I've mentioned, go back. The next judgment I've mentioned, detailed guidelines were issued by Honorable High Court. This is the judgment which I happen to be a part of, where we had represented the taxpayer 398 ITR 198. The name of the judgment is Sub Infrastructure. In this, Delhi High Court went a step further and laid down 4 more guidelines. Certain kind of information needs to be given because, like we mentioned, it's a special power which is given to the income tax officer. So guidelines were laid down as to how can this power be exercised in the most efficient and efficacious manner as opposed to it being arbitrary. So certain further guidelines were laid down saying information needs to be given, the copy of the approval taken by the senior officer needs to be given. So as and when we moved through the regime of the erstwhile provision, a lot of law kept developing. And these are concepts you don't find within the letter of law because the statutory provision of 147, 148 are just 2-3 paragraphs which give the framework. But how is the framework to be applied and exercised? It all came up through the jurisprudence which developed over the period of time in the entire last 2 decades, I would say. So this is how we were standing as on 2021. And then we can skip the next few slides. These are all time frames given under the old law. Just to say that the old law was, of course, a very detailed law, but a lot of concepts developed over a period of time. Then, of course, came 2020, but before that, before I would talk about COVID and how COVID has contributed a lot to today's controversy is something I'll touch in for 5 minutes from now. But then came in Finance Act 2021. Finance Act 2021 recognized and appreciated the fact that, yes, there's been a big change in terms of how reassessment was looked at and the reassessment scheme was looked at under the erstwhile regime and how it has developed a lot over a period of time. So the legislature, and this is something we also find mentioned in the speech by the Honorable Finance Minister, where they say that a lot of systems of checks and balances are there. And they also appreciated the Supreme Court judgment of GK and Raifsha that I was just talking about. So GK and Raifsha, that judgment which said that yes, as a matter of an additional check and an additional fetter and an additional safeguard, there'll be one more order, which has to be a speaking order, which the assessing officer will be passing before he continues the proceedings. This essential part has now been accepted by the legislature in Finance Act 2021 and it has been made part of the statute. So now the Finance Act 2021, which talks about the entire reassessment mechanism, The entire mechanism, the entire framework has completely been changed. And one of the biggest and the major changes is that GK and Raifshaw has been incorporated as the law by the legislature within the rule book itself. So it now forms part of the statute, which is something which was judge made back in the days, like we saw, which was the norm which was being followed in the last 2 decades. So the legislature accepted that yes, this position, this framework which the Supreme Court has created in terms of a system of checks and balances is the way forward. So one of the biggest changes that they proposed in the Finance Act 2021, alongside other provisions, is the fact that GK and right has been statutorily incorporated. Now the new provision is section 148 capital A. And if we go through the entire framework, it talks of 4 stages. That 4 stages is nothing but a statutory incorporation of the law which was laid down in GK and Rights Act, which basically says the assessing officer will conduct inquiries. He will issue a notice to the income tax, to the litigant, sorry. Then the litigant has the right to oppose the same. After considering his objections, which I mean, the word we used to use was objections under the erstwhile regime. Now they say after considering his reply and his response, they will pass a detailed and a speaking order, which is essentially what GK and Raifshaw back in the day had stated, that you provide in the reasons recorded to the taxpayer, he objects, and then you pass a speaking order. So it is the entire same framework with a little small changes here and there, which stand incorporated within the letter of law now. Now he can conduct inquiries if he wants to. The assessing officer, he will show cause, put to you to notice that yes, I have this information and I wish to reassess you. You will object to that, by virtue of which he will pass a detailed and a speaking order. So this is one of the biggest changes in the Finance Act 2021. Other changes are in terms of timelines. Under the erstwhile regime, the timelines were more in terms of 4 years, 6 years, 16 years. That means you can reassess a person within 4 years from the end of the assessment year. This is the old provisions. 4 years from the end of the assessment year, then 6 years from the end of the assessment year, then 16 years from the end of the assessment year. These timelines are of primary importance because it is in the best interest of the litigants and it is in the best interest of the sovereign that at some point of time your income tax returns are closed, and the scrutiny and the certainty and the clarity that we get becomes very important. Which is why, I mean, as lawyers, we all understand the importance of limitation, right? And the most important rationale of limitation is always that at some point of time there has to be certain clarity and certain certainty, and an end and a full stop needs to be put to certain kind of proceedings. And it's the same concept for section 149 and your reassessment. As it is, you are using the extended powers and you did not assess a person originally, and then you reassess and you use your special powers. So when you're using your special powers, then I think timelines become very important, because as it is, you are exercising a special power. So there has to be some certainty and some full stop somewhere down the line, right? Which is why these timelines become very important. So under the erstwhile regime, before Finance Act 2021, it was always typically 4 years, 6 years, 16 years. Most common was the 6 year. 16 years was to do with foreign assets, etc. 4 years was only for the time when the income is less than 1 lakh, so very small. 6 years was the most common one. So mostly people would have to wait for 6 years from the end of the assessment year. And if I count from financial year, then another year ahead, right? So that is the number of years people had to wait to get a full closure to the income tax return, which practically speaking is a long enough time. Because don't forget, guys, that we are talking about income tax, we are talking about each financial year, each assessment year. Each financial year is treated separately, and these timelines independently apply for each year. So if today I'm talking of financial year 7 years back, and every year the person is subjected to this, then yes, it's a long time for a person to maintain that data, to explain it to the income tax officer 7 years later, that 7 years before I did this transaction, these were my documentation, this was the vendor, maybe the vendor doesn't exist now, he sends him a notice, that person doesn't respond, he has closed his business. So the assessing officer may want to take a view that your vendor hasn't responded, he was a bogus company, I will not give you the benefit. A lot changes over the last 7 years, right? So for somebody on the flag end of the 7th year to receive a notice and then, explain the entire framework and the transaction can sometimes be a tedious task, which is why these timeframes become very important. Under the new regime, the timeframes are now basically 3 years and 10 years. Very simple. Not that simple, but at least simple in terms of two identifications. Back. So it says this is the new period. I mean, again, we won't get into detail, but 3 years and 10 years. So in the old regime, if you guys notice, it was 4 years, 6 years, 16 years. Now it is 3 years and 10 years. But for 10 years, there's a fetter. for 10 years only if the income, which is, according to the income tax department, which is alleged to have escaped assessment, is in the form of any asset which leads to about 50 lakhs or more. So this additional monetary limit of 50 lakhs has been put in. And how does one look at 50 lakhs in terms of what does 50 lakh represent itself is going to be a big litigative issue somewhere down the line. Not to do with present controversy, but yes, how does one represent and understand 50 lakhs in terms of income having escaped assessment becomes very important. So I'll give you a very simple example. You purchase a property, then you sell it. When I'm selling, my selling cost could be 1 crore, in which case it is more than 50 lakhs. But of course, my purchase cost is only 80 lakhs. So shouldn't it be 1 crore minus 80? I mean, is income in the pure form of income, or is it my sale consideration? Because if I look at 1 crore, then I've crossed this limit. But if I do 1 crore minus 80 lakhs, then I've not crossed this limit. So a lot of controversies are also likely to arise in terms of how will one look at 50 lakhs. Will 50 lakhs be looked at a gross level, or will it be looked at as a net level? Then there is a concept of 50 lakhs representing an asset. Then what do you mean by an asset? It could be an asset in the hands of the taxpayer, but the assessing officer may not accept it to be an asset, or vice versa. In fact, Finance Act 2022. So this is the new law which came in, and unfortunately, the government at that point of time did not clarify asset. So in Finance Act 2022, there's already amendment to this concept. So what I'm trying to say is it's a confusion after confusion which is getting created every year. After so many years, a law was changed finally in Finance Act 2021. So one would imagine that yes, if after so many years a law is being changed, the law will cater to these aspects, right? But unfortunately, some of these aspects went missing, which is why Finance Act 2022 has brought about more changes. So of course, there's going to be a lot of uncertainty in terms of how will one understand this. But this is not important in terms of the present controversy, so we can move ahead. After having explained the basic differences in terms of old law and the new law, let's try and look at the controversy. And for that, we'll talk a bit about TOLA, the famous TOLA, and and how COVID kind of added on to this confusion. So what happened was Finance Act 2021 got introduced, and the government said that from 1st April 2021, the new law will apply, and the new law will substitute the old law. So the entire framework of the old and the erstwhile regime of 147 and reassessment goes away. There's a new law, and the new law, with whatever the new law is, let's not get into that discussion right now, whether it's a good law, it's a bad law. But the new law will apply from 1st April 2021. This happened in February and then March and then 1st April 2021. But before that, let's step back and let's look at the fact that COVID had hit in, and hence time periods had been extended by the government in terms of the situation that we were facing in India in terms of lockdown. So we had the famous TOLA, which is the taxation and the other relaxation, or once the ordinance came, then the law came in 2020. And if we look at the exact provision of Section 3 of TOLA, which is just on the next slide. Yes. So basically, TOLA gives the power to the central government to extend any time period. That means all time periods which were getting, for example, let's say they were getting time barred on 31st March 2020, or they were getting time barred on 31st March 2021, keeping in mind the fact that the country and the world was undergoing a pandemic, these time periods stood extended. And this is very important because only the time period stood extended. So on one hand, we had a new law coming in. We had the parliament changing the entire law, moving from the erstwhile reassessment regime to a new regime, which the Honorable Parliament stated to be effective from 1st April 2021. Parallelly, we had TOLA in Section 3, which gave power to the central government by notification to extend timelines under any law. So on one side, we have Parliament, which is altogether saying that the old provisions are now out and they are outdated, and they are being substituted by the new provisions, which are being effective from 1st April 2021. Alongside, we also have the Parliament, which enacts the TOLA, through which they delegate the power. Now, this is important because this is something they don't do themselves. They delegate the power to the central government that wherever required, you can extend the timelines. So these are two parallel things which are happening around the same time, around March 2021, right? Now what happens is the government, the parliament obviously legislates, and Finance Act 2021 becomes the law of the land on 28th March 2021. Alongside, in 2021, And if you remember, on 31st March 2021, they issued one notification. Then immediately in April, unfortunately the Delta variant hit in, so they needed more time, and rightly so, right? In terms of extension. So two notifications were issued by the central government to extend the law, and this is one notification. And they're similarly worded. So one notification came on 31st March 2021, another notification came on 27th April 2021. And in both of these notifications, they stated that we are extending the timelines for issuance of 148 notice under the erstwhile regime. Now, this is very important. They say that we are extending the timeline for issuance of notice under the erstwhile regime. If you see the explanation that I've highlighted, it says before the commencement of the Finance Act 2021. So they say under the erstwhile regime, the time period for issuance of notices stand extended from 31st March 2021 to 30th June 2021. And these are notifications which are being issued by the central government. And very important, these are being issued by the central government on 31st March 2021 and on 27th April 2021. But on 28th March 2021, the Finance Act 2021 has already received the assent of the president and has already become the law of the land. So once there's already a law of the land which is made by the parliament and which has received the sanction of the president and is effective from 1st April 2021, then the question that arises is that how can the central government, by notification, which is of course a delegated legislation, how can they extend the timeline for issuance of notices under the erstwhile regime? Because the new regime is very clear, which was made effective from Finance Act 2021, that Finance Act 2021 will now govern the 148 operation, and the old law is dead and substituted. So something which is dead and substituted and has received the signature of the President of India on 28th March 2021, could it have been extended under delegated legislation by the central government on 31st March 2021 and 27th April 2021? That's the legal controversy for which everybody rushed to High Court. And then this is the crux and the sum and substance of the entire debate. One of the most core issues, right? Of course, if you ask my personal opinion, I do agree in terms of what various high courts said, that something which is already dead, because the old and the erstwhile regime was already dead, it was substituted, it was repealed, it was removed from the act, and a new provision had come in which had already become the law of the land on 28th March 2021, effective 1st April 2021. Then the central government, under the power of delegated legislation, did not have the authority to say that no, the old law will not apply, sorry, no, the new law will not apply and the old law will apply, and we will continue issuing notices under the old law, and we will do that up till 30th June 2021. Just read the explanation which is on the screen. It says it is hereby clarified that for the purposes of issuance of notice under 148, as per the time limits under the old law, etc., as the case may be, they will continue to apply as it stood on on 31st March 2021 before the commencement of Finance Act. So what the central government is saying that no, president having signed on 28th March does not matter. We will apply the old law and we will continue applying it till 30th June 2021. That is the controversy. The central government got this power under TOLA. TOLA is the law which came in terms of relaxation of timelines when COVID had set in. And TOLA only gave, and Section 3 of TOLA only gave power to the central government to extend timelines. But it nowhere gave them the power to substitute one law from another law, especially when the parliament and the president of India has already substituted the law. They cannot change that being delegated legislation. That is the sum and substance of the controversy. Out here, if you see, Section 3 is very clear. It says where any timeline as specified within so-and-so period, which falls within so-and-so period, is to kind of end, then on account of COVID, we are, letting them pass notifications to extend the timeline. So the only power given to the central government is to extend timelines. But in the garb of extending timelines, they cannot change the law. If the parliament and the president says that the law is, which will be effective from 1st April 2021 is the law that we stated to be under Finance Act 2021, then the central government cannot say that no, that law will not apply and still the old law will continue to apply. And if you see the explanation which I had just put, the two notifications which were challenged in high courts, this is the sum and substance of what they are doing, right? This is being issued under the power of delegated legislation by the central government. They say that for removal of doubts, it is clarified that notices issued under the erstwhile regime as they stood on 31st March 2021 before the commencement of Finance Act 2021. Whereas Finance Act 2021 has already become the law of the land on 28th March and is already effective and part of the law as on 1st April 2021 onwards. So the central government cannot, and that was the submission of the taxpayers, do this because they had no power and authority to supersede what the parliament is saying in terms of the applicability of the new law. So these notifications and this explanation dated 31st March 2021 and also 27th April 2021 were challenged in different high courts, saying that this is ultra vires. These explanations, the notifications issued, these explanations is ultra vires and the new law becomes applicable. Now it is very important because the new law, and this is something which even the Supreme Court notes, that the new law is a law which is there, which has recognized the problems on reassessment law over a period of time. Which is, I remember I told you, GK and drive shaft of the Supreme Court judgment has now been incorporated statutorily and has been made the law of the land under Section 148A. So these are very important problems that were recognized and appreciated over a period of time. That yes, XYZ are the problems, and hence these problems were appreciated, and which is why they were put as part of the law. So the argument of the taxpayer was that when there's been a change of the law and a new regime which benefits the taxpayers has been introduced, then of course one is entitled to receive notices under the new law, but why have them issue under the old law? Because the old law already stands repealed and substituted by the new law. And I'll just read one paragraph of the Supreme Court judgment because they recognize that yes, the new law is a law which is there for the benefit of everyone. Supreme Court in para 7 says that the new provisions which are introduced by Finance Act 2021 are remedial and benevolent in nature and are substituted and are changed in law with a specific aim and purpose to protect the rights of the assessee as well as the taxpayers. So all the problems that existed under the erstwhile regime, see practically whether these problems are solved or not, I'm not on that because practically even I feel the problems are not solved. But right now, let's talk about the fact when we are moving from an old law to a new law. Every time you move from an old law to a new law, the aim of the sovereign is always to ensure that the problems being faced under the erstwhile regime are being taken care of, right? That is why they make a substantive change in the law. So as far as the aim and the purpose of the sovereign is concerned, which is to undo with the problem that we face under the old law. And it is with that aim and objective that you're bringing in a new law. So if that is the aim and the objective, which is remedial in nature and which is to take care of the problem that the taxpayers face, then of course the new and the beneficial provision should be made applicable because they're already the law of the land from 1st April 2021, which is why these were the few arguments of the taxpayers. So the controversy started in June. So immediately a lot of people started receiving notices from 1st April 2021 to 30th June 2021. Now I'll just talk about what happened practically. A lot of people received these notices. 90,000 notices were issued. The first High Court, I think, where this matter went was Bombay High Court, June 2021. Delhi High Court was, of course, on their summer vacation, but Bombay High Court, I'm guessing, must have opened by then. So the matters went there. High Court granted a stay, an interim stay on the impugned notification and also on the impugned notices. First week July, Delhi High Court opens. These writs start getting filed in Delhi High Court. Delhi High Court also starts staying. Slowly and slowly, Rajasthan High Court, Kolkata High Court, and then almost pan India. I don't think there must be any High Court which did not entertain a 148 petition on this notice, on this issue. All assessees started rushing in to high courts. A lot of Punjab, Haryana High Court, any High Court you name, Gujarat High Court also, Madras, Karnataka, Tamil Nadu, all of them. And I myself represented a lot of assessees in different high courts. And after a period of time, final hearings also started happening. Initially, there were interim stay granted on the impugned notification and the impugned notices. And then the first High Court, in fact, to rule in favor of the assessee was Allahabad High Court. But the first ever High Court to rule was Chhattisgarh High Court, and Chhattisgarh High Court took a view in favor of the revenue. Chhattisgarh High Court, the matter was heard by a single judge and not by the DB because that is how the process goes, at least in Chhattisgarh High Court. And they went on the larger scheme of COVID. They said no, COVID had extended the timelines, which is where this confusion happened. And a lot of these arguments were also not considered, but the court went on a larger perspective of COVID and hence ruled in favor of the in favor of the revenue. So the first ever High Court to adjudicate on this issue was Chhattisgarh High Court. The first ever High Court to adjudicate in favor of the assessee was 30th September 2021, which was Allahabad High Court. A big win for taxpayers after the fact that Chhattisgarh High Court had come in. And of course, Chhattisgarh High Court judgment was considered, it was distinguished. And thereafter, the next judgment which came in was Hon'ble Petition, which was all keep taking a view in favor of the assessees. What does Delhi High Court and all these high courts, what do they more or less say, right? I have just put in 2 slides on Delhi High Court to just show mostly what they say. These are all the high courts. I've just mentioned details. So again, we won't read into this, but the court obviously says that Section 3 of the Relaxation Act, which was TOLA, was giving powers to the government to only extend time limits, and it did not delegate and give them the power to decide which law can they apply. The law that was to be applied was definitely the new law because it had received the assent of the President of India on 28th March, and it was the law of the land from 1st April 2021. So the law TOLA was in the background of COVID, and the background of COVID was from the point of time that the country and the nation is undergoing a big pandemic, as a result of which all timelines cannot be met. It is not possible when we are on a sudden lockdown back in March 2020 and then also in March 2021 to complete all the proceedings. So only and only for that limited purpose can you extend the timelines. But in the garb of extending timelines, you cannot choose which law will you apply. And this is the sum and substance of what Supreme Court, what High Court say, and what all other High Courts also say. If we see the next slide, I know this is a bit detailed, you don't have to read it, but the sum and substance remains the same. And in para 102, they also say revenue cannot rely on COVID-19 because COVID-19 and when the TOLA law was there, at that point of time, of course, the law was there since 2020, the TOLA law. So once the Finance Act 2021 came, the Parliament was aware that there is already a law which gives them the power to extend timelines. Yet they changed the law because obviously the Parliament knew that extending timelines is a very different concept from changing the law, and they can go ahead and change the law, and nothing prohibits or forbids the Parliament from changing the law, because TOLA is only for the purposes of extension of timelines, and it has nothing to do with the crux and the sum and substance of the reassessment regime. The reassessment regime is a different regime. The substantive provisions, the timelines, the information to be supplied, the process and procedure to be followed is an entirely different regime. It has nothing to do with the extension of timelines on account of COVID. So obviously the Parliament in February 2021, when they brought about Finance Act 2021, were very well aware that these are two different concepts altogether. And even though the country and the nation is undergoing a pandemic, nothing stops and prohibits the Parliament from changing the law, which is why they went ahead and changed the law. And that law had become the law of the land from 1st April 2021. Now, last paragraph is very important, I would say. Para 104 talks about relief. They say that the notifications are ultra virus because they go beyond the power, beyond the scope of the power and what was permitted and what the central government could have done. So they were held to be null and void and unconstitutional because, like I mentioned, the central government could not have decided which law will they apply when the Parliament had already legislated upon a new law. Para 105 is a little important because what the court does, and this is what Supreme Court modifies, they say that all these notices are quashed. These notices were issued basis these notifications, which we are saying are ultra vires and are unconstitutional. Supreme Court upholds that. But in para 105, when Delhi High Court said we are quashing the notices, and now the Income Tax Department and the Revenue can decide whatever they wish to do. If the law permits them to send notices under the new regime, they can do so. Whereas this is the sum and substance of what Supreme Court picks up. And what Supreme Court does is now I'll move on to. So all these high courts adjudicate, the matter goes to Supreme Court. The matter goes to Supreme Court. Supreme Court modifies all the high court rulings. And Supreme Court says that yes, High Court is partially correct. They could not have done it. But the revenue cannot be left remediless. And now this is where Supreme Court talks about the concept of a balancing act. Whether it's a balancing act or not, we'll have to, of course, discuss it a bit further. But what they go ahead and they say that yes, the notifications are ultra vires, but all these notices are not to be quashed. The argument of the taxpayer was that if there's a new provision, then the new provision should have applied. So the Supreme Court accepts and they say that all these notices under the old regime are deemed to be notices under the new regime. So 90,000 notices have been issued. 9,000 people approached High Court, different High Courts pan India, out of which SLPs by the department in Supreme Court were filed in only about 10 to 15 cases. So about 10 to 15 cases was the subject matter of litigation before Supreme Court. All 9,000 SLPs had not even been filed. 81,000 people had not even approached court, because 90,000 were the notices which were issued and only 9,000 people had approached court. Out of which 10 to 15 were the cases which the income tax department picked up and filed an SLP against. So 10 to 15 people were in court who were actually representing. So 9,000 minus 10 to 15, so let's say, which is a big number itself, against whom the notices had been quashed were not even in court. 81,000 people had not even started the entire litigation framework, because they were just holding back and seeing probably, as to how will this entire controversy move. Supreme Court lays down the law under Article 142. Supreme Court says that yes, the law that we are laying down applies to all 90,000 assessees to whom these notices have been issued. They agree partially with all high courts that yes, the notifications are incorrect. Then they also accept the argument of the assessees that you want to be subjected to the new law. So you will be subjected to the new law. So your point is also accepted. But all these notices are automatically notices under the new law. So what the High Court had done was, High Court had quashed these notices, and High Court had said that if the Income Tax Department permits and if the law permits them, they will go ahead and issue these notices again. But this is the line that Supreme Court picks up and says that no, that is not required, because it may leave the Income Tax Department remediless, because 90,000 cases may not again be eligible to reassessment under the new regime, or whatever could be other permutation and combination on account of 3-year tenure that I mentioned, or on account of that 50 lakh interpretation that I mentioned. So the court automatically said that all the 90,000 cases are deemed to be valid under the new law. Then they say the assessee wants the benefit of the new provision, so we are giving them the benefit of new provision. We are saying that these are all notices deemed to have been issued under the new law. This is what para 7, 8 and 9, which is the sum and substance of the Supreme Court judgment, this is what they say. And in that point of time, what Supreme Court very interestingly also says, Supreme Court exercises the power under Article 142. Can you just go to the next slide? Supreme Court exercises the power under Article 142. Article 142 is a very rare power. It's a constitutional provision. It's there under the Constitution of India. It's a unique provision. It is, of course, exercised in very rarest of rare cases, for sure. And as far as taxation is concerned, it's always been a great exception, right? Maybe 1 or 2 times, I think Justice Rumapal and Justice Sikri at one occasion have only exercised this power. Otherwise, this power under tax regime has not really been exercised. So, of course, it's a constitutional power. It's a very unique and a discretionary power. It's a matter of, let's say, a trust doctrine, wherein, in terms of balancing the equities, where to do complete justice, and that's the wording which is used under Article 142, that to do complete justice, you are exercising this power. Now, interesting question that arises for us is this complete justice? Is this complete justice when 90,000 notices were issued, out of which 81,000 people never even approached court? And today they have a verdict which is binding on them when they never even started the litigation. This is Supreme Court basically legislating and making the law, right? Usually only those people will get an answer from court who start their litigation and who go to court. Out here, 81,000 people already have an answer which today is against them when they did not even go to court, which usually is not the case. But this has happened because court has legislated instead of deciding a controversy which was before them. So usually a judgment will be binding inter-party to the extent that yes, Supreme Court lays down the law of the land for sure. But the application is only qua those parties who have come to court, right? If court says A has to pay B 50,000 rupees, then yes, the rationale and the reasoning behind the court having to pay 50,000 rupees, A having to pay B 50,000 rupees is the law of the land. That's, of course, the law of stare decisis or whatever you want to call it. In terms of that's the law of the land, right? But the applicability is always only on A having to pay B 50,000 rupees. So qua the two parties who were the litigants in the present proceedings, right? But this is a case where 90,000 people received notices, 81,000 people did not even go to court, and they have a verdict today. And 9,000 people who went to court SLPs qua their matters were not even filed. Only 10 SLPs were filed. 9,000 people got their notices quashed from different high courts. 10 of them were challenged in High Court. Sorry, were challenged in Supreme Court. As a result of which, even they have a verdict now. So this is what is this? This is of course Supreme Court, legislating and going beyond what normally happens. And this is the bare rarity in the tax regime, because you don't really see this within the tax framework, right? Now, Supreme Court in Para 9 also terms it as a balancing act. They say this is to balance the interests of the assessees and the taxpayers. I'm not quite sure whether this is balancing or not. I mean, assessees would definitely not want to call it balancing, because an assessee would say, when I had one from High Court, at least those 9,000 assessees had one from High Court, they had got their notices quashed. 81,000 also, in all probability, would have had the same fate had they gone to court, because, of course, the same law would have applied to them as well. So, once the assessees already had something in their favor, to go to court, and then the matter, like I said, because these are all assessees that I'm talking about, barring those 10, against whom the matter never even proceeded to Supreme Court. Yet they have a verdict where they say that no, your notice is High Court is correct, because this is what Supreme Court says. High Court is correct, but the revenue cannot be left remediless, as a result of which these notices are deemed to have been valid under the new law, which is essentially what the Parliament would do, right? Parliament will legislate upon these issues in terms of whether these notices are, I mean, in terms of deeming fiction. When we talk about deeming fiction and deeming applicability of something which is common within taxation, then that is something always the Parliament does, right? That deemed to have been issued under, or deemed to have been income escaping assessment, or deemed to have been a foreign asset which you have not disclosed. So those are deeming concepts which the legislature legislates upon. But for the Supreme Court to do it is something which is, of course, unheard of, right? And then in Para 8 and Para 9, Supreme Court is accepting that if we take a contrary view, that means if we allow what the High Court has done, then there'll be no reassessment proceedings, because High Court said that you can issue under the new law if the new law permits. But the new law, for XYZ reasons, may not permit. Because, like I mentioned, 50 lakhs, how do you look at 50 lakhs? The different parameters under the new law could be very different mechanisms, right? So then the Supreme Court recognizes this problem, and it says the revenue cannot be left remediless, and the object and purpose of reassessment will get frustrated if we leave the revenue remediless. So they accept that the reassessment procedure and mechanisms right from the beginning has been only to safeguard the interests of the revenue and not to safeguard the interests of the assessee, which is a very important point. Because, like we know, this is a special power which is given to the revenue. And if the 148 regime and the reassessment regime is always to protect only the revenue, then where do the assessees stand? Because this is the case where High Court is and Supreme Court is accepting that the notifications were incorrect. They are accepting that the income tax department went wrong. They are accepting that the notices have been issued under the wrong provision. Yet they are saying that our aim and purpose is only to protect the interests of the revenue. And somewhere they use the word public exchequer. So they are going on a policy issue. Of course, they are going into the fact that the sovereign as a whole needs to be protected, irrespective of the fact that yes, mistakes have been committed. So is this really a balancing act? And that becomes a very big question mark. Then, of course, they say that this is a bona fide mistake. And this is very interesting, because what happens when there are bona fide mistakes by assessees within the tax regime? How is one supposed to deal with that, right? When there are bona fide mistakes, I don't file my income tax return, I don't disclose an asset I have in London, and I say it's a bona fide mistake. Will the income tax department accept it to be a bona fide mistake? They'll presume that this is a case of concealment. So, what about bona fide mistakes which are committed by assessees? And this, I mean, is this a mistake? I mean, I'm sorry, but this may be a blunder. This is not a mistake. Everything was kind of well aware of, and there was a law. And somebody is sitting cannot just say that no, this is not the law, and I will still continue to apply the old law. So there are a lot of these questions then come in. And then they also say, again, they say that there was a genuine understanding that the old law will apply. And, all those are words which have been used in Para 7, 8, and 9 of the Supreme Court judgment. And then they say some leeway should be given to the income tax department. Now, are leeways in law actually given to assessees? So, an assessee will feel that why, I mean, and, this is where the assessee will say that this is not a balancing act, because those leeways in law are never given to me. So why give them to the revenue, right? Now, what is the concluding part of now this is where they have laid down the guidelines in Para 8, which is in front of you. They say these are all notices deemed to have been issued under the new regime. I'm on point number 1. because very short timelines have been given by the Supreme Court. If you see point number 1, I know it may be, the font may be a little small, so I'll read it. They say that these are all notices deemed to have been issued under the new law 148A subclause B, which is the new regime. The AO shall within 30 days from today, 4th May 2022, this judgment comes, so 30 days from today, provide to the respective assessees. That means all 90,000 assessees, because they have clarified it in para 9 that this applies to all 90,000 assessees. So from today, provide, that means give to the respective assessees information and material which the revenue has, so that the assessee can reply to that within 2 weeks thereafter. That means the watch has already started from 4th May 2022. Only 30 days time is given to the revenue. And in all fairness, I accept that the 30 days is a very small time. For assessing officers to give this information and follow the entire procedure across the country for 90,000 assessees is a big task for them. And I accept this, in all fairness, more time should have been given to the revenue. Thereafter, only 2 weeks is given to the assessees. 2 weeks could be a short time because, of course, let's talk about practical issues, right? Those 2 weeks, I'm not well. I ask for an adjournment. I ask for extension. The assessing officer may say that he may say that no, Supreme Court binds me. I have to, otherwise I'll pass an ex parte order. Even though there's a circular which is issued on 11th May, and the CBDT has clarified this. So there was big hue and cry, which started on 4th May. The moment this judgment came, morning was a pronouncement. Every day, the whole day, everybody was just talking about what will be the exact language. Around 6 o'clock, the judgment came on the Supreme Court website, and since then there was big discussion within the entire tax framework and the entire tax industry, that what is going to happen. So yes, 2 weeks could be a short time thereafter for the assessees also. Thereafter, he says that the law and the entire process will be followed. Now, what is most important is the last point. All defenses which may be available to the assessees, including those under section 149 of the IT Act, the new provision, because he says these are deemed to have been notices under new provision. So we are out of the old provision now. So he says all defenses which may be available to the assessee, including that under section 149, and all rights and contentions which may be available to the concerned assessees and revenue under Finance Act 2021 in law shall continue to be available. So now this becomes another sum and substance of controversy in terms of understanding section 149, and I'll explain in some time why. But before that, I'll just tell you what has happened after this. So there was a big hue and cry in terms of understanding, because a lot of questions go unanswered. A lot of questions go unanswered in terms of how does section 149 reconcile, which all defenses are available under section 149. Let me also tell you guys one very important thing. Section 149 of Finance Act 2021 is a new law because it has just come in last year. It has not been subject matter of any litigation to date. How does one interpret 50 lakhs? How does one interpret asset? How does one interpret these timelines, which is section 149 is on the screen right now for you? How does one interpret these provisions? This has not been subject matter of any litigation. So isn't it obvious that this is bound to create more confusion? Because all Supreme Court says that all defenses of 149 are available. But how does one apply these defenses? How do I look at 50 lakhs? How do I look at asset? How do I look at 3 years? How do I look at 10 years? Which assessment years are 3 years? Let's say there's a dispute between me and the assessing officer that this is within 3 years or this is not within 3 years. Or this is 50 lakhs or this is not 50 lakhs. Then how will one resolve that? So those are some open-ended questions. There are provisos to section 149, which are very important provisos, which are going to be highly litigative in future, because first proviso to section 149, with all due respect, is not providing a lot of clarity on a lot of aspects. So this became a big issue in terms of understanding on how will one apply the law. Then what I've been given to understand is that because this judgment came in, it had to be immediately implemented within 30 days from the department side. CBDT on 11th May 2022 has just issued a circular, which in our opinion maybe creates some more confusion, because their way of understanding section 149 is very different from your and my way of understanding 149, for example. This is what at least they have stated. They say few assessment years will be subject to 50-year time period, and few assessment years will not be subject to the time period in terms of 50 lakhs. So they classify it assessment year wise. They say these 3 assessment years, 50 lakh applies. These 2 assessment years, no 50 lakhs. Even if it's 20 lakhs, you will be subject to your reassessment and your notice will be valid. This is what they say. But what is very important and what remains unanswered is the first proviso to section 149, and I think this can lead to a second round of litigation, and I'll explain why. Section 149, which talks about time limitations, first proviso says that what which assessment year could not have been opened under the old law cannot be opened under the new law. See, whenever there's a transition in law, one is always concerned about the main assessment years under question, right? How will they be subjected to, whether under the old law, whether under the new law? How will you do that transition? So I think, and this is why legislature kept first proviso to section 149, because the purpose and the aim of first proviso to section 149 was to ensure that in the transition, nothing worse and more harmful, which is against the interest of the taxpayer, happens. So first proviso says that notice under the new regime will not be issued if at the time of issuance of notice time period under the old law had expired. That means if under the old law you could not issue notice, then we will not issue notice under the new law. So as to ensure that the transition is smooth, and so as to ensure that when you're moving from one law to the other law, more grave prejudice is not caused to the assessees, and the assessees are not at a worse off position. In my opinion, at least, that is the aim and purpose behind proviso to section 149. So when the Supreme Court says the entire defense of 149 is available, how does one interpret first proviso to 149 becomes a very big question mark. CBDT circular 11th May 2022 does not answer this at all. The biggest controversy now would be what will happen to first proviso to section 149. They only answer it assessment year wise, but they don't answer it. And I'll tell you the reason. Because the proviso to section 149 says that what could not have been reopened under the old regime will not be reopened under the new regime. And what could not have been opened under the old regime as per the time limitations were AY 1314 and AY 1415. And maybe also AY 1516, which for some people believe it to be, in favor of the SSC, some in favor of the revenue. So I will leave AY 1516 for now. AY 13, 14, 14, 15, there is large consensus within the industry, and I'm not just speaking for myself, I'm speaking for a lot of experts in the field who have been writing articles, who have been speaking on different webinars and forums ever since 4th May 2022. So as to say that AY 13, 14 and 14, 15 were under the old regime, rightly so, getting time barred as on March 2021. So they could not have been opened under the old regime after March 2021. Hence, they cannot be opened under the new regime. That means they got untested at completely. Is that possible? Because Supreme Court also in one line says that can the assessment year can it go untouched at all because of this change in law? So this is likely to be a big issue. And also, let me tell you, practically out of 90,000 notices which have been issued, at least 70 to 75,000 notices pertain to AY 13, 14 and 14, 15. So the large chunk of the debate remains on the proviso to section 149, which remains completely unanswered by Supreme Court. It remains completely unanswered by the CBDT guidelines, which they have issued on 11th May 2022. And I think purposely so. Because nobody knows how will it be interpreted. So nobody wants to maybe, which is why CBDT being very well aware of section 149, because they've clarified it in the paragraph which is on the screen right now. But I think maybe it's a conscious decision to not touch upon the proviso, because it is a controversial proviso and it is likely to, maybe create a second round of litigation, or likely to have some impact on these 90,000 cases for sure. So on one side, you have a school of thought which says that what could not have been reopened under the old law, which is the understanding of the proviso, and that was with the aim and intent to ensure that the transition is smooth, will now not be open. Because had we been under the old regime, let's say today there was no Finance Act 2021, and today there was no TOLA, timelines were not extended, COVID is over, then today AY 13, 14, 14, 15 could not have been reopened. And there's no dispute on that. I'm clear about that. So just because now we have moved from an old regime to a new regime, can AY 13, 14 and 14, 15 be opened? Maybe the proviso is there, proviso to section 149 is enacted by the legislature to take care of this problem and to ensure that the transition is smooth and to ensure that the taxpayer is not worse off. Because why else is the proviso there, right? But can it be taken to such a great extent by saying that AY 13, 14 and 14, 15 have become sacrosanct and they'll never be touched? Old law is over. Notices were not issued under old law. They were issued, this controversy started, they are now deemed to have been issued under the new law. If the proviso is interpreted in such a manner, that means AY 13, 14 and 14, 15 have become sacrosanct, They have attained complete finality, and no matter what, they can never be touched upon. And like I said, practically speaking, out of 90,000 notices, at least 70 to 75 notices, 75,000 notices pertain to AY 13, 14, and 14, 15. So now, and Supreme Court, like I said, is silent on the proviso to Section 149. Supreme Court in one line says all defenses of Section 149 are available to the assessees, which of course includes the proviso. The question is not whether it is available to us or not. The question is how does one interpret and apply Section 149 and the proviso to Section 149? Because it's a new law which has come about only last year. There's been no litigation at all. There is no jurisprudence available. There are no guidelines available. So the sum and substance of what boils down to the controversy today is how does one apply Section 149? And also the CBDT instructions, in all fairness, are not binding on the judiciary. They're binding on the assessing officer. They're not binding on the taxpayers. Taxpayers are free to challenge the CBDT circular dated 11th May 2022. It is not binding on the courts also. And of course, this is again a clear law. It is only binding on the income tax department and the assessing officer. They will apply it. We are free to challenge it. Court is free to take a different view, which is why there are too many open-ended questions right now. Because like I mentioned, Supreme Court in one line very clearly says that how is it possible that an assessment year goes untested and untouched at all, right? Para 8, first line of Supreme Court. At the same time, judgments of the several High Court would result in no reassessment proceedings at all. Even if the same are permissible under Finance Act 2022, the revenue cannot be made remediless, and hence the purpose of reassessment will get frustrated. So on one side, you will have one school of thought saying that the proviso to Section 149 cannot be interpreted in such a manner that 2 assessment years become completely sacrosanct and go untouched. And on one side, you will have a view which will say that if AY 13, 14 and 14, 15 haven't become sacrosanct and can still be touched, then what is the aim and purpose of the proviso? Then what is the proviso doing there at all, right? In the book, it's just a dead letter. So this is the biggest question, and maybe 70 to 75,000 cases would still have an impact. I think I've quite exceeded my time, so I will probably end now. Sum and substance of the debate remains the same, like I mentioned. And there are again too many open-ended questions, but as and when the flow goes, as and when the notices come about, as and when people reply, we will start having more clarity as to how to apply and interpret them. Thanks, Jay.
Well, what can I say, Ananya? I think I just witnessed one of the best presentations on the virtual Amicus. This is exactly what I wanted. All this while, from speakers discussing complicated legal issues, complex issues, solving them and doing it in simplest of the terms so that it's easier for everyone to understand and comprehend. This is what exactly, the endeavor was always to do that. And finally, we've got something that we always wanted. What an outstanding performance. I think if assuming that this session was a film, I would rate it 9.5 on IMDb. And I'm not kidding. The effort that you've put in, and it's not easy to approach a taxation dispute in a storytelling way and then connecting it with the masses who have absolutely no clue about it. So, you've done a brilliant job. And well, I just have a couple of questions, but only if time permits, because this session has already taken a lot of your time.
No, you can do them.
So I think one question that I had in mind was with respect to the expenses that have been incurred by assessees. Pan India, they've been in and out of litigation from constitutional courts, both High Court and Supreme Court. Do you think the Honorable Supreme Court should have kept something in mind for them as a compensatory measure, if not completely, then probably partial compensation from the revenue to the assessee in terms of the expenses that they've incurred, because they virtually perpetually get nothing out of this?
Yes.
In terms of litigation costs as well.
Yeah. Thank you. I remember I was mooting back in the days, and obviously it was a moot. So the judge asked me, "You want costs?" And I was like, "Who doesn't love costs?" Yeah, for sure. If you're ruling in my favor, you give me costs, right? And that is something which is so true, right? I mean, 81,000 assessees did not go to court. 9,000 assessees went to court. And what about their time? What about their litigation expense? You accept that revenue has done a mistake, and which, like I mentioned, it's much more than a mistake. But if they have done a mistake, then compensate, right? I mean, that's the least you can do. Like I said, when we do a mistake, are we given that benefit? Is our mistake always considered to be a bona fide mistake? That really depends, right? So that leeway in law is not given to us, and why give it to the department? And I completely agree. A lot of people will want to argue that cost, let's say 50,000, which is a big amount, right? maybe not that big a amount for the revenue in terms of public exchequer, because the Supreme Court is looking at it as a policy issue, and they're looking at the public exchequer as large. So then maybe, and then, at that point of time, 50,000 rupees per, let's say, per, per assessee could be given to those 9,000 people. But again, and the other way of looking at it would be, why no cost? Because this is a pure legal issue. It's not a malified intent. It's not like the income tax department went particularly after A assessee or B assessee and you weren't like personally targeted. It was a pure legal issue. And like you see, even all the judgments, it's purely legal. Your facts are not really gone into. All those 9,000 matters are kind of heard together as bunch matters in each high court, because it's a pure legal issue. So to say that, yes, I've incurred litigation costs for sure, but I've not been personally targeted. It's not a personal vendetta of the income tax department qua you. If that would have been the case, then for sure, and then you ultimately win and your time is lost, and it is proved that income tax department is wrong and they targeted you or they went after you. That is a case when one can claim costs, saying that this is, but this is a case which is a lot more than that. If it's a larger public policy issue in terms of applicability of the law, in terms of understanding the regime, then maybe costs wouldn't fit in, at least in my opinion there.
And question number two, how often do you see Article 142 of the Constitution of India being excised in such matters to do complete justice? I mean, was it even required to do so?
I completely agree. It was, I mean, we've all taken aback for sure. One would not have thought that this is the answer Supreme Court will come up with to find. But I think if this is what Supreme Court had to rule, then they had no other choice. If 90,000, 81,000 people haven't even approached court, so how to pass a verdict which will apply to them? And those 9,000 may say 10 SLPs had been filed. Okay, they could have gotten the department to file for all others, which would be a pure copy paste and a waste of time and resources for sure, because it's just a pure copy paste and taking them to court. But still, the max they could have done is applied the law qua 9,000. And then you can't create an artificial, I would say, an artificial difference between 9,000 and 81,000 only because 9,000 went to court and 81,000 did not go to court. So in this, that would be clearly violative of Article 14 also, right? Just because an assessee sat back with his notice is valid. Just because somebody went to court, his notice is not valid, because the notice is arising from the same notification. So that would create an ambiguity. So the only way I think for Supreme Court to resolve this and to make parity within all 90,000 taxpayers was to use this power. Whether the usage of the power is correct or not is a separate matter altogether.
And lastly, the scope and power of a review petition in these matters. Do you think that review there is enough scope for a review to be preferred, or if at all it is being preferred already by SSEs?
Yeah, I don't think court will do this. I think from the first para of Supreme Court, they are very clear in terms of the movement that, the direction in which the judgment is likely to go in terms of protecting the interest of the revenue. And in terms of, at various places they have said that some leeway needs to be given, the aim and purpose of reassessment will get defeated. So I think the sum and substance of the judgment is in a particular direction. I don't see a review being entertained and completely taking us to the other side for sure. I think assessees have to accept that this is the fate. And one should not keep much hope on a review petition, is my personal understanding.
Absolutely. Very well then, to all the viewers who are watching, if you still haven't subscribed to the Virtual Lawmakers, then definitely it's your loss, and it's a loss that is irreparable. Thank you so much, Ms. Ananya Kapoor. You've set high benchmark for the speakers to come, and I hope you've not given them complex for all the upcoming sessions that are lined up. But tremendous work that you've put in, and it shows. Congratulations to you and your entire team for doing this, for making it successful. And I'm so happy that I approached you for this session, and I can assure you that I will trouble you more in near future for such complicated issues, to help young lawyers and young viewers understand these intricate complex tax issues and disputes decided by constitutional courts of our country. That has always been an endeavor to do it in the simplest of the ways so that it's easier for everyone to understand and comprehend. Thank you so much, Ms. Ananya Kapoor, once again for this session. Any parting words, anything that you wish to say towards the end?
Just wanted to thank you for having me over. It's an amazing platform. It's a very good initiative, Jay, that you have taken, and I must congratulate you for this. these are things that we all want to do, but I think we are just so stuck with code and day-to-day regime that hum kar nahi pate. And you are one of the exceptions who's gone ahead and created this platform, which is an amazing platform. And I think this platform will really help a lot of students, a lot of people who are just in 1 or 2 years of, in their litigation career or in their corporate career, in terms of just understanding practical frameworks. Because this is something which we didn't have back. We didn't have much of this kind of access to these kind of platforms, back when you and I were in law school. So we would just kind of, wait, listen to people around. But now, of course, technology has changed so much, and students and youngsters are making maximum use of this, and it's a great platform. And you're just bringing people from different arena to it together, so it's lovely. Super congratulations to you for your platform. It's an amazing platform.
Thank you so much, Ananya, for all the kind words. I think speakers like you that make these little virtual initiatives extraordinary, everything sounding extraordinary. And thank you so much once again to all the viewers who are watching. Email is mentioned on the channel. I'm 200% sure that 99.9% of all your queries must have been answered by now. If there could not have been a better presentation on this issue, on this dispute. But if you still have one, feel free to write to us. We'll be more than happy to forward the same to Amicus for today's session. You can even write to her directly if you want. And it's goodbye for now. Thank you, Ananya. Thank you so much.
Thank you. Thanks.